Okay, good afternoon, ladies and gentlemen. It's been an interesting day so far. Not going to get into politics because I don't do politics, but I think it's important to kind of go over the purpose of the show because we're going to try something new today. I'm going to tell you about it in a minute. The purpose of the show is, number one, to provide you with information for people who are just interested in getting information about how the system works from the inside. What I mean by the inside is I spent a lot of years trying cases, jury trials and otherwise, and I've spent almost 10 years now on the bench. So it's a wealth of experience that I want to share with you informationally, just informationally. Number two, I want to entertain you to some degree by using these cases that I've had over all these years, both as in the trench and from the bench as well, because if it happened to somebody else, it could happen to you.
Yes.
And when people think, oh, it's a walk in the park, it's a piece of cake, not so. And that way we give you a chance to get an understanding of how things really work. Third, we try to help you by giving you guidelines, no advice, but guidelines as to what you should do if you find yourself about to be involved in the legal system or you're already in it. And one of the worst things, I think, for most people is the unexpected. When people don't know what to expect, it's a normal reaction to be stressful, to be anxious, because you don't know.
Exactly.
So what we do here is we tell you what you could reasonably expect. And you don't get that only from a lawyer, because that's just a lawyer talking to you. But you get a reasonable expectation from somebody who decides the cases.
You.
Me. Well, that's true.
I know.
And I didn't realize it. I was thinking about it today. I didn't realize it until I guess it was when I first started to do some actual trials as opposed to restraining orders and things, even though there are trials there too. And I looked down at the lawyers and I saw how incompetent some of them were. I didn't say anything, of course.
You didn't tell them how bad they were?
I didn't do it.
Oh, you should.
I didn't do it. Not like that judge I told you about before who told the kid, where's your state bar card? Nobody would have given you a license.
It's terrible.
But I looked down and, I had to read briefs. I read briefs all the time. And you realize when you read some of that stuff that the quality of some of the lawyers is not that terrific.
So, Judge, for the layman who doesn't know what a brief is, A, tell us a little bit about what a brief is, and B, does the lawyer write the brief normally?
Okay, that's a very good question. A brief is basically a statement of the facts. That's the first part of a brief usually.
Of the case?
Of the case. Here's the facts. This is what happened. A and B had a contract or whatever it is. And the second part is what they call points and authorities. Points and authorities are basically references to the law. As I've said before, there's a concept in the law. It is the concept in the law, really, called stare decisis. Stare decisis means precedent. So if the exact same case happened last month and it's published, then it serves as the authority for whatever position you have that's consistent. Most of the time, cases are distinguishable. If some facts change, dates change, issues change a little bit, and those cases, which we talked about a couple of weeks ago, are distinguishable. And when you ask me about narrow decision, well, that's what I mean by a narrow decision.
Okay.
And then the latter part is the prayer.
The prayer.
I know.
I pray, I get.
I want. This is because of you, what you did to me. This is what I want. These are my damages.
Okay.
So the prayer is relief. What can you get for what it is? And so the plaintiff, if a civil case, because there's not a lot of brief writing in criminal cases, very little, as a matter of fact. That's the difference between civil and criminal. Civil is very paper heavy, a lot of dialogue and a lot of motions and things like that, and criminal is not.
So do both lawyers write briefs when it's a
Yes.
civil case? And if it's a criminal case, is it just the DA laying out the case? Is that what the district attorney?
In fact, the case that I'm going to talk about today, there's going to be a motion made there. Normally, we don't make motions.
Okay.
But in a civil case, the plaintiff files the brief first, or if they're making a motion is a request to the court. That's just a fancy word for that. They're asking for certain kinds of relief. They file a motion. Motion could be filed by a defendant. Oftentimes, defendants file what's called summary judgment motions, meaning they want the case to be over right then and there, saying even if you're absolutely right on everything, there's no disputed issues of fact, here's the law, we win. That's called a summary judgment motion.
Okay.
So the plaintiffs usually make a motion to compel a defendant to do something. A defendant can make a motion to compel a plaintiff to answer interrogatories, which are questions, to compel the taking of a deposition, which is an examination in front of a court reporter, usually in a lawyer's office or a court reporter's office, where all kinds of questions are asked. It's a fishing expedition.
Right.
That's a deposition. Some of them can go on. I've been in depositions that went 2 weeks.
Wow, that's a lot.
Every day.
Oh, my God.
2 weeks. Yeah, that case I had in Fresno, which I talked about long ago, we took almost 200 depositions. It was a very big case, and it was a very long time.
That's a lot of depositions.
A lot of depositions. So to get back to the point, you can force somebody to answer questions.
Okay.
Many times a defendant or even a plaintiff will say, I'm not going to answer. You have a right to get that answer, unless it's privileged. Now, privilege means, in legal terminology, there's a protection against disclosure. In other words, between an attorney and a client, that dialogue, no matter what it is, with some minor exceptions under what they call the criminal fraud exception, most of the time that's privileged communications. Well, you're hearing that about Michael Cohen and all of
Yes.
that. That's what they talk. Is it really privileged?
Is
maybe
it?
Yes, maybe no.
no.
And somebody files a motion, and somebody responds to the motion. So in a civil case, the plaintiff files either a motion or a complaint or some other document. The defendant has a reasonable period of time, it's established by statute, to respond. Sometimes you get an extension, or the court will give you additional time. It's discretionary, but that's all goes along with how do you practice,
Mm-hmm.
And then usually the moving party gets the last word. And the reason for that, I always say this in when I take the bench in the mornings, I always say, the reason that the plaintiff or the moving party gets to go twice is because they have the burden of proof.
Right.
And I would say easily 70% maybe of cases are decided on something called burden of proof. If at the end of a hearing or at the end of a trial you say to yourself, I'm not really sure, because the party with the burden of proof loses. Generally, it's the plaintiff in a civil case, although if a defendant raises something called an affirmative defense, statute of limitations, there's a variety of affirmative defenses. In fact, in the form books that they have, there's probably 50 of them, affirmative defenses.
Wow.
When you have an affirmative defense, the burden of proof shifts to the party with the affirmative defense. They have to prove the affirmative defense. If they don't meet that burden, then the affirmative defense doesn't work. And so this whole thing is a back and forth thing. The system is really geared to a two-party, although I'm going to talk about a case today that there's more than two parties. But generally, it's just two parties.
It's like a tennis match almost, volleying and back and forth.
Yeah, and there are rules. In fact, today, what we're going to do is something different.
Okay.
I try very hard. This is a 30-some-odd show, I think.
Something like that, at least.
Yeah, well, I try to mix it up so that it's not always the same thing every week. And I always said to people who listen to the show and like it, I said, if I was just sitting here and talking for 55 minutes, this would be a bore. I got Gary.
Oh, yeah.
Gary,
wow.
Gary gives me entertainment.
Oh, yes.
Some good softball questions, make me sound smart.
Oh, yeah. Sure. Because I sound stupid? Is that what you're trying to tell me?
No, in fact, in the acknowledgments for the book, which is called From the Trench to the Bench,
yes,
I acknowledge 3 lawyers who have been with me for more than 25 years. That they always make me sound so smart, and they did all the work.
There you go.
So, credit where credit is due. We'll talk about what we're going to do today after the break.
All right. It's Judge Herb Dodell for the people. If you want to ask the judge a question, you can email him. Yes, you can email him at askjudgeherb@gmail.com. We'll be back with the judge right after this.
AM KCAA.
Herb Dodell is a lawyer and a judge for the people. Having served as a Superior Court judge, presiding over more than 9,000 cases, He has witnessed firsthand how complicated and corrupt the legal system can be. His goal is to show how things really work in the legal system so that people can navigate the legal system in the best way for them. Many people often feel marginalized by the legal system and are uninformed about how to proceed when unfortunate circumstances arise in their life. Judge Herb will pull back the curtain, lift the veil, so people can truly understand their rights, have access to top legal personnel that they can trust, and have knowledge about how things work so they can make better choices. Judge Herb isn't just knowledgeable. His integrity and spiritual values are truly what make him different. He cares about democratizing access and information for all and desires to turn on the light so the people, you, can benefit. For more information, email the judge at askjudgeherb@gmail.com. That's askjudgeherb@gmail.com.
Okay, I should also mention the fourth element of the purpose of the show is to introduce a little spirituality, because much of what we talk about is rote. It's all determined. It's by statute and everything else. But there's another element that goes into all of these cases, and that's a spiritual element. What I mean by spirituality has nothing to do with religion.
Right.
It's about how you feel and how you act and how you react to other people. And that ultimately determines what's going to happen to you at the end of the day. It's all about cause and effect. So we do that too. So we have lots of different elements. And today I'm going to try something new.
Okay.
I already told you, you know.
I don't, but go ahead.
Okay. Well, I mentioned it last week, actually.
Yes.
And I'm just thinking, my New York accent has never gone away for whatever reason it is.
Hey, yo.
A word comes out every now and I say, God, that sounds like a New Yorker. A New Yorker.
A New Yorker.
So we try to do something different every week. So this week, and I mentioned it last week, I think, in the show.
Yes, you did.
I'm going to give you a real case, a real honest-to-goodness case, current criminal case.
Really?
Yeah.
All right.
You know, a lot of the good lawyers, the quality lawyers, will oftentimes do something called a focus group. And there are companies that, like Schlesinger, that does focus groups. In other words, you put on a mock jury trial, and you see what the people that you pick, what they would do if this was a real jury trial. So we're going to kind of try that as a kind of an experiment here.
That's cool.
And I'm going to call this segment, what do you think I'm going to call this segment?
Trial by error. I don't know.
You be the judge.
You be the judge.
You
there
be
you
the
go.
judge.
Okay, I
Because
like it.
you're all going to be
I
the
didn't know what the hell it was.
But the point is, what is a jury? A jury is just a group of citizens that are picked up out of the hat.
Yeah.
And if people are smart enough to be listening to this show, I want them on my jury.
Yes.
And so you're all the jurors out there.
You're the jury.
And then at the end of the show today, I haven't really decided how I'm going to do it, but at the end of the show today, let me know what you think. In what party wins, what party loses. And nobody's going to jail here, hopefully.
I know I'm not.
Well, but it's an interesting case. And
Okay.
Before we go into the actual facts of the case, I'm going to give you some issues, some legal principles. This goes into the idea of giving you information. Most people will watch TV, they'll see a closing argument that lasts 3 minutes.
Of course. Law and order.
They don't last 3 minutes. And you hear objections and you see the person, he or she sitting up there with the black robe on, you know.
You, like you.
Yeah, well, you know, we make the decisions.
Right.
And people say, why did he or she sustain that objection? Sustaining an objection means you agree with the objection.
Yes.
Okay? That's when a judge says sustained, you know.
Right.
And then the other side of that is overruled.
Overruled.
Overruled means sit down.
Shut up.
And in fact, I tell this story all the time. I had a case many years ago. I remember the guy. I'm not going to mention his name because I don't want to embarrass him. But he objected to almost every question I asked. It was a 2-month trial. He objected to almost everything.
That drive
And
you
there
crazy?
were two defendants. One was an insurance company, and this guy was representing an insurance agent. He stood up, sat down, and I'm looking at the jury, right?
Yeah.
They don't want to be there.
Right.
The last thing they want to be doing is sitting in a hot room and listening to a bunch of lawyers arguing back and forth. Up and down, up and down. We won the case. I had a horrible client, by the way. I'm sure he burned it down. I'm not going to mention. I'm not going to mention his name. But
You still won.
I have no idea. Yeah, and I became very, very close friends with the other defense lawyer, who later became a judge. We became very close friends. But when the jury came back, this is the jury where the one guy was sitting in the front. He was a baker and he had a cane. He came and he limped in. And when I was up doing good things, he was up there giving me the thumbs up, you know.
Are they allowed to do that?
He was doing it.
Oh, I mean, didn't the judge or the other attorney?
Nobody said nothing.
Nobody said anything
Nobody
about
said
it.
anything at all.
Wow.
The judge was Elizabeth Ziegler. I'll never forget her. She was the sister of one of the district attorney.
Yeah.
And I talked to him. Oh, when the other guy was talking, he was sleeping. He was absolutely snoring, sleeping.
Why wouldn't they try to kick him off the?
Who knows? You know,
That's crazy.
But there's a possibility that the judge might have done something about it. But you got to ask.
Right.
If you don't make a record of it, it doesn't exist.
So why didn't
That's
the DAs do anything? I don't understand that.
That was a civil case.
Oh, it's civil case. Okay.
The bottom line was, I talked to this guy who later became a client of mine, as a matter of fact.
Yeah.
And he said they were so annoyed with this guy. They were so aggravated, but he was keeping him there and making all these frivolous objections because she was overruling 98% of them.
Yeah, made him look like a dope.
And that's exactly why they went for us.
Of course.
So jurors do what jurors do. There's a concept in the law, for those of you out there who haven't heard it before, it's called jury nullification.
Yes.
Jury nullification means you're not paying attention to what the judge tells you to do because you want to be ruling in one party's favor versus the other. And so you nullify all the rules. You just do. And it's very hard. In fact, it's almost impossible, to contest a jury verdict based on deliberations. You're not allowed to go into the deliberations. You can't ask a statement after a trial. What were you thinking about?
Yeah.
Unless it goes to prejudice or some kind of some violation of law. In fact, I experienced that problem. They hurry to get out. Weren't interested in deliberating.
Well, look what happened with OJ. They had it on there for over a year, and they spent a day or something. I mean, it happens all the time. You hear about these trials going on for months and months and months, and then I guess the jury gets so worn out from all of it that they've already made up their mind.
And sometimes they fold. And I had a 5.5-month trial, a criminal case, many, many, many years ago. I know exactly when it was because my son was born during that trial. It was a 5.5-month trial. And there was, at the end of the trial, there was some serious evidence against my client. I thought we had a hung jury all along, and a hung jury means they can't reach a verdict.
Right,
and
mistrial.
It ends up in a mistrial. And notwithstanding evidence, videotape evidence against the client, jury deliberated for 9 days. Admittedly, it was a long trial, but they deliberated for 9 days, and they finally came up with a verdict, a guilty verdict. And I talked to one of the dissenters. Really, it was no dissenter at the end. It had to be 12-0.
Right.
But they had hung out. It was 10-2 for a long time, and the two folded because they were exhausted.
Yeah, worn out. That sucks, though.
Worn out, and she was crying to me on the phone.
I mean,
literally crying to me how she felt it was improper and it was a miscarriage of justice, but she folded anyway.
And you can't do anything about that.
No, you can't.
You can't appeal that?
No. You can only appeal juror misconduct. In other words, if a juror says, and when you start deliberations, I don't want to deliberate, they're guilty. You may not even get that. If you take a statement, we took statements in a trial because we couldn't imagine why the result was what it was. And the answer was they wanted to go home.
Oh.
It was a Friday afternoon, a 3-day weekend. One person had a vacation starting the following weekend.
Goodbye.
One said, who cares about these people?
Right.
We had all of this memorialized.
Wow.
Didn't do us any good.
Really? Can't appeal it?
We did.
And what happened?
Well, what
Nothing.
happened was in that case, one of the jurors, remember, it's a Friday afternoon.
Yeah.
One of the jurors said to the bailiff, "How long do these things generally take?" Looking at the watch. And the bailiff, for whatever reason, said, "Oh, an hour or two will be plenty."
What?
Yeah, and we got that in a statement from one of the jurors. That's what the bailiff said.
That's got to be.
And we took,
grounds for
we
appeal.
asked for a new trial.
Yeah.
On that basis.
And
We had two jurors who was supporting it. It's an 8-person jury in Arizona.
Mhm.
And the Court of Appeal, the judge denied it. We took it up on appeal. The Court of Appeals agreed with us and ordered a new trial.
wow.
Went to the Supreme Court, reversed it, said, so what?
Really?
They didn't. They found that it was not so significant as to make an ultimate difference. And I think that what really happened was they didn't want to open the door to everybody complaining about verdicts being the wrong way.
Right.
And they didn't want to open the floodgates to every case being a motion for a new trial. But the bottom line is juries do what juries do. So you, ladies and gentlemen, are the jury
The jury today.
in this case.
Okay, let's hear it.
And you're a focus group. So you can always let me know by sending me an email at askjudgeherb@gmail.com. And I'd appreciate your input.
Yeah.
I'm going to give you the rules now because almost all of you are lay people. And some of the things that are happening in this case are legal issues. And you need to know what those are because some of the objections that are going to be taken by both sides during the course of this, a judge is going to decide whether to sustain or overrule those objections. So you need to know what the law is so you can get a better idea as to why the judge is or isn't doing something with regard to the objections and ultimately what's going to go to the jury at the end of the day.
So there's a criminal case.
Criminal case.
Okay.
Criminal case.
I'm ready.
Are you?
I guess.
Okay.
I mean, I'm here.
No. You are what they call a captive audience.
I am.
But you know what? Unless you're really a nice guy, you're not going to get a chance to vote.
Oh, okay. I won't vote.
But you have a vote right now.
Okay.
When we finish for the day, you can tell me what you think.
All right. I will. Guilty or not guilty?
Guilty or not guilty? Well, remember, first thing I should tell you.
Yes, please.
See these little liners that you give me one here and there?
Yeah.
Inspire me to come up with another subject.
Okay, cool.
The rule.
The rules.
The rules.
Do it.
We already talked about one rule, and I will tell you that nothing that I will tell you during the course of this show or otherwise will involve any attorney-client communications. Now, there's nothing that I will tell you comes from a conversation between me and the client.
Okay.
Same thing that happens in a civil case with regard to the burden of proof. We talked about that. Different burden of proof in a criminal case.
Right. Total.
Civil, there's 3 different burdens of proof. So before we start with the facts of the case, there's 3 different kinds of burdens of proof. The first is called preponderance of the evidence. Many of you folks are listening to the show for the first time. Maybe you have heard a couple of them. And by the way, if you want to know what the subject matter of each show is, if you go to the website and hit radio shows, it'll have basically an index or a table of contents.
And what's the website?
The website is judgeherbdodell.us.
Okay, judgeherbdodell.us.
So if you wanted to hear the interview with Roger Stone,
Oh, that's so interesting now.
that was
Now it's really
it's going to get
interesting.
more
I
interesting
know.
now.
Maybe we can get back on the air.
I don't think Roger's going to be talking very much these days.
We don't know. Maybe he would.
You know what? He was gregarious enough. He might be willing to do that.
He was very cordial.
He was surprisingly intelligent, actually. But the bottom line is that when the burden of proof in a civil case is called a preponderance of the evidence, meaning more likely than not. So for all of you who have never listened to the show or whatever, I maybe repeat myself a little bit so I put things in context. But we're going to have to wait to do that until after the break.
All right, look forward to it. It's for the people of Judge Herb Dodell, and get his book From the Trench to the Bench. Available on Amazon. Prime Amazon today is the day. Prime Amazon. Go get the book. You'll get a discount possibly.
People are doing the book because I'm being told that the numbers are going up.
Cool.
DC Talk Radio, 1050 AM, KCAA.
In his book, From the Trench to the Bench, Judge Herb Dodell demystifies the legal system, including both civil and criminal, the lawyers, the judges, and the process. As a judge, former deputy district attorney, and criminal defense attorney, he knows the legal system. He has the inside information that you need to pick a lawyer, and he's here to give it to you. No matter what you're facing that makes you think you may need a lawyer, Judge Herb will shed valuable light on your situation and reveal your best options and many secrets of how the judicial system actually works. To find out more about how the legal system really works, you can get your copy of Judge Herb Dodell's eye-opening book, From the Trench to the Bench, at Amazon.com.
Okay, we're back with the burden of proof. Preponderance of the evidence means more likely than not. So looking at the scale of justice, if it tips a little bit onto one side, that's meeting the burden.
Okay.
In a criminal case, it's beyond a reasonable doubt to a moral certainty. Most people don't add to a moral certainty, but that's what the code said for many years. Probably still says the same thing. But beyond a reasonable doubt means reasonable doubt. There's going to be doubt in most everything. And I tell you, as criminal defense lawyers, we always looked at creating doubt. It was never trying to prove anything. We never really wanted to prove innocence. And I mentioned this probably 10 shows ago. I always argued to a jury that the verdict form is the thing that the jury signs at the end saying what they want to do. The verdict form has guilty and not guilty on it. It has nothing on there that says innocent.
Right.
And so I remind the jury that there's either guilty because it's been proven by the prosecution with the burden of proof beyond a reasonable doubt, or you have to check the box that says not guilty. Not that they're innocent. It's just that they haven't been proven to be guilty. It's an argument that you make. Well, you have to make that argument.
No, I understand.
Look, I used to make the argument about clients who didn't testify. It's not like taking the fifth. They don't say, I'm taking the fifth. They just don't testify.
Right.
And many jurors, I always thought, would say to themselves, well, if the guy really or the gal was really innocent, they would have testified. I was always concerned that there was kind of like a presumption or an inference that they must have done something, otherwise they would have told us about it.
Yeah.
And so in the early years, I used to say something. They don't have to testify, and they're not obligated to. And there's a jury instruction, and I'll define that in a minute. It says they don't have to testify, and you shouldn't draw any inferences from that or anything like that. I don't do that anymore. Well, I haven't tried to. Well, I'm trying one right now. As a matter of fact, this case is a real case.
This is a real case that you're trying right now.
It's my case.
Okay.
Well, I'm defending along with two other lawyers.
Okay.
This guy. So let's get to the case.
Let's get to the case.
But now I didn't mention the third burden of proof.
Okay.
So to be thorough, there's a burden in between called clear and convincing. Clear and convincing means it's somewhere in between preponderance and beyond a reasonable doubt.
Well, that's civil, though, right?
That'd
be criminal too.
There are cases where you apply clear and convincing. Generally, not. Criminal is not usually, almost always beyond a reasonable doubt.
Yeah.
But on certain issues within a criminal case, there may be an occasion where you use that burden on the admissibility of evidence and things of that nature.
Okay.
And remember that the judges decide what gets into the evidence.
Right.
Cases cannot be determined without evidence to support it.
Okay.
It must be supported.
Okay.
In fact, what's one of the reasons that you make a motion to dismiss at the end, or what they call a motion for a directed verdict?
Not enough evidence.
Not enough evidence. And so your job as a defense lawyer is to keep it out if it's going to be damaging to your client.
Yeah.
We talked about a motion to suppress.
Right.
Most people don't know what that means. It means that you keep it out from the court, allowing it to go to the jury. That's a motion to suppress.
Keep it away from the jury.
Yeah, they never know about it.
Right.
And I told the story a couple of weeks ago about the client who there were two defendants. They were writing to each other, and it was in the back of a truck that the police searched. And there was this terrible admission, And the prosecution, of course, wanted to get it in, and we fought to keep it out.
Yeah.
In fact, my co-counsel on that case, his name was Charlie Marginis. He's now the presiding judge in the Orange County Superior Court. We tried the case together. And we did everything known to man to keep that document out, and we did.
That's cool.
At the end of the day, it didn't make a whole lot of difference, but
Right.
we did keep it out. So now let's get to the case.
Let's get
before
to
we
the
run out of
case.
time.
Yes.
Okay. Got a client's a doctor.
Okay.
He has a medical
Doctor of
practice.
what?
A doctor, medical doctor.
Okay, medical doctor, not dentist, but
Medical doctor.
okay.
I'm going to change some names and some incidents
Well, I hope
here
so.
to keep it from being recognizable.
Okay.
So
All right.
anyway, he had a former partner who he didn't get along with. They were having an affair, and it didn't work out, and they really didn't like each other very much at the end.
The two doctors.
Two doctors.
Had an affair,
Yeah, they did.
and then they broke up.
They broke up.
Okay.
They were working together.
They're working together at this office.
It wasn't doing too well. And this case, by the way, is insurance fraud.
Okay.
That's what this case is about.
All right.
First, there was a water damage claim in 2012. My client was not the policyholder. It was the ex-partner.
Okay.
Then there was another loss. He still wasn't the policyholder, and she was. And then in January of 2014, there was a water damage. The place flooded. And somebody had Mickey Moused the toilets upstairs in the medical offices so that
Well, they flooded them out.
they flooded them out. They stuffed the toilet with paper. And,
sure that's what it was?
And the little they call it a flapper. I never knew
A
that.
flapper.
You know that thing you press that turns the water on and off?
Yeah, the
It's called
flapper.
the flapper.
Yeah. Yeah.
Somebody messed with the flapper.
Somebody flapped the flapper.
Yeah, but it's going to be very significant, this flapper.
Out. Okay.
Not a flipper, it's a flapper.
The flapper.
And they have this big water loss.
All right.
By then, he owned the business,
Okay.
and he owned the property, and he was also the policyholder, different insurance company from the prior ones.
Mm-hmm.
And I mentioned the prior ones because it's going to play a big role in the unfolding of the evidence in the case. And then a couple of months later, somebody broke in. Didn't take much, broke in. And then 2 days later, the place burns down. Down to the
Down to the ground. So it
basically
flooded.
down to the ground.
It flooded and then it burned down.
Yeah, well,
It's sort of weird.
but the interesting thing is they got the guy who burned it down on videotape.
Oh, really?
And it's not my client.
That's not your guy.
No.
Okay.
But my client had hired a contractor to fix the water damage months earlier, and it was going slowly and taking a while to get done. He hired this contractor.
Mm-hmm.
And the contractor had an employee. The employee's on the video.
Oh, you're kidding.
Showing up at the place, boom, up it goes. He didn't go up with it, no proof for him.
Right.
And they got him on videotape.
Okay.
And so the doctor makes the claim for the proceeds from the water and from the fire,
Mm-hmm.
and the insurance company is not paying.
Okay.
He didn't want to give them what's called an examination under oath, which the insurance company is entitled to take to ask you questions.
Right.
When there's a criminal case that might happen,
Mm-hmm.
the policyholder is allowed to defer doing anything while that criminal case is a potential. And so he was advised by his then lawyer not to give the insurance company anything. You know the reason why? Because the insurance company takes whatever they get and they turn it over to the district attorney's office. They're looking to get you prosecuted. They want you to get prosecuted.
Yeah, so they don't have to pay off.
Exactly. Happens all the time.
Right.
In fact, that's what I did for many years, and as I was practicing, that's what I did. Chased insurance companies. And the reality was that he wouldn't give him a statement. They denied his claim. And then probably about 6 months later, maybe a little bit longer than that, he retained me to do the civil case.
Mm-hmm.
And I talked the lawyer from the insurance company into withdrawing the denial. I said, I'll give you the examination. It's years after this fire. You got a guy on video who's figuring there's going to be a criminal case, right?
Right.
So I give it to them. They reopen the claim and they pay it. Not all of it. They pay part of it,
Mm-hmm.
but not a lot of it.
Right.
And so he sues them in a civil case for the policy benefits, right?
Mm-hmm.
And in the defense of their case, they do not allege fraud in the answer to the complaint, which is kind of amazing.
That's weird.
But the bottom line was the district attorney has now filed a criminal case against my client, the contractor, and the employee of the contractor, and alleged that it was an insurance fraud, that this is a loss that was caused by the insured for the insurance money.
Right.
And as evidence of this, they're claiming a conspiracy, that all three of them got together to make an insurance claim. The contractor would make some money. The insured would get the building paid for. It was for sale at the time, and that's what they did. They conspired. Now, the law of conspiracy is very interesting. We talked about that one day during one of the shows maybe a month ago.
Mm-hmm.
If two or more people combine, get together to commit an illegal act, an unlawful act, that's called a conspiracy.
Yeah.
And a conspiracy is different than the actual act itself. It's a separate real charge.
Mm-hmm.
And so they allege that these guys conspired with each other to make this fraudulent insurance claim.
Wow.
And to support their case, they ask you, the jury, to believe that this employee burned the place down because he was going to get something from him. There's no evidence.
So they were saying that he was going to get paid off.
Yeah.
That the doctor was going to pay the employee off to burn
Or
the
the
place
contractor.
down. Or the contractor.
Right.
Okay.
Right.
Okay.
And that guy is being tried separately for the arson.
Oh, really?
Yeah.
The employee.
Yeah. Well, you know what risk there is when you have multiple defendants? Let me tell you what the biggest risk is with multiple defendants. Somebody flips.
The flipper.
The flipper messed with the flapper. And the bottom line is that's always a risk in any criminal case when you have multiple defendants. It used to be, it was called the Aranda case. It used to be that you had to try them separately. Now they try them together.
Oh, they do?
But not this one.
Okay.
The arson is being tried separately than from the insurance fraud cases.
Wow.
Now, also, there's something called the statute of limitations.
Yes.
People say, statute of limitations? Is there a statute of limitations in a criminal case?
Yes.
What do you think the answer is?
Of course there is.
What do you think it is?
Depends on what the crime is, I believe, isn't it?
Yes and no.
Well, I mean, on statute of on murder charges, there's no statute of limitations. That's what I'm saying.
No statute of limitations on kidnapping either.
Oh, really? Okay.
But there is a statute of limitations for pretty much everything else.
Well, of course, but aren't there different statutes, like for rape, composed to insurance fraud? Is the same?
The statute.
It's the same thing. Okay.
Penal code is pretty specific.
I did not know that.
It is 3 years from discovery.
Really? Discovery of what?
Of the crime.
A discovery of the crime.
But remember, in a conspiracy, and here's where I want the audience to get involved. In a conspiracy, the statute doesn't start to run until what's called the last overt act. Remember that term, last overt act. I explained it in one of the old shows.
Yeah.
Which is the last thing that was done in furtherance of the conspiracy or to abandon the conspiracy.
Okay.
So there's a clock that runs.
Yeah.
Now, this water loss took place in January of 2014. The complaint, the criminal complaint, and I'll explain the difference between a complaint and an indictment. The complaint was filed in 2018.
Well, that sounds
well. You don't have to be H&R Block to figure out that's more than 3 years.
Yeah, I can even figure that one.
And so their argument is that they didn't know what was going on until much later. It's called a Zamora allegation, and it comes from the case of People versus Zamora, old case.
Okay.
1976, I think. That's not old.
Not that old.
No.
We were both around.
Yeah. I was having a good time those years.
So was I.
Hasn't stopped.
All right.
Well, we'll talk about the rest of it and the defense when we come back from the break.
Okay, cool. It's For the People, Judge Herb Dodell. If you want to ask the judge a question, ask Judge Herb at gmail.com, and he'll answer any question he can. We'll be back with the case.
Okay.
The arson case right after this.
NBC Talk Radio, 1050 AM, KCAA.
Did you ever meet a lawyer that was for the people? Someone who had the best interests of the people at heart? Herb Dodell has been a lawyer for more than 50 years and has been a Superior Court judge for 9 years, having presided over more than 9,000 cases. In this show, he will reveal the secrets of how things really work in the legal system, so you can maximize your position and benefit most when you're in trouble and need someone on your side to simplify the process for you. For more information, email the judge at askjudgeherb@gmail.com. That's askjudgeherb@gmail.com.
So the statute generally is 3 years.
Okay.
There are some exceptions that gets extended, like I just mentioned on the Zamora case, and there are other cases too that extend statutes of limitations. But what makes the case more interesting, I think, is the allegations of the conspiracy, because as long as the conspiracy is going, the statute of limitations hasn't run. That's why they allege that. And so I had mentioned before these prior losses that took place when the former partner owned the business. Why is that relevant to what happened here? There are two different losses and whatever. And by the way, the employee that set the fire had also made 2 separate claims on his own house for water damage.
Oh, that's weird.
And guess what caused the water damage?
Toilet.
It's the flapper.
It's the flapper. It's
And it
the
was
toilet.
the same thing.
Wow.
So obviously there's the guy, this is what his MO is.
Yeah, that's weird.
And well, it's helpful in a lot of ways.
Oh, yeah, for you.
And in fact, there was a burglary in between one of these claims. And it turns out that the furniture that was that took all the furniture and computers and everything else, she moved her medical practice to some other location. And guess what was in that location? All the furniture.
Oh, my God.
All the furniture and the computers and everything else.
Really?
So guess who did the burglary? You know.
Of course.
I mentioned all of these because I want to introduce enough elements for the public to think about it. And I'm going to tell you about the defense side now.
Okay.
One of the arguments was that he hadn't paid his taxes, business taxes. But there were facts that controverted that. All they have is all these similar events. And there's something called common scheme and plan. You cannot use character evidence in any criminal case unless the defendant puts character in issue. In other words, you can't say, I'm the greatest guy because I've never done this, that, and the other thing. And they can bring in all kinds of evidence to contradict it, but they can't start it. You can only respond to it.
Mm-hmm.
It's in California, it's Section 1105. And so they want to get all these prior acts to show a continuing course of conduct. Whether or not that gets into evidence is decided by who?
The judge.
The judge is going to decide whether to get.
Of course.
Why is it so important? Because it's the prejudice, the potential prejudice is monumental.
Can turn the case.
Yeah, if he did it before, he did it again.
Of course.
And that's the inference that they want to get out of it. So during the course of this trial, it will come up. It will come up because they're going to try to introduce it and we are going to object to it.
Okay.
And whether or not it gets past the judge or not remains to be seen. The same thing with the last overt act. You know, the position could be taken very simply that the overt act was the actual water damage or the fire. It had nothing to do with anything else. Their argument is probably going to be that, well, you know, he's still trying to collect the money.
Yeah, it's a continual thing.
Yeah, well, that's what lawsuits are about. And I should tell you, and I'll try to do it today if I can, but let me just tell you what the defenses are. They also claim that they have cell phone records, but they don't have any information what's on those cell phone calls. None. You know, he called his girlfriend. What does that have to do with anything? Oh, that means he was right after the fire. He was calling people stuff. The same thing with the taxes, stuff. That's their circumstantial evidence case. Remember we talked about circumstantial versus direct?
Yes.
The video is direct.
Right.
Circumstantial is you didn't pay the taxes and therefore you burned it down.
Yeah.
So there's no evidence to support that there's anything on any cell records. And there's no evidence whatsoever that he had any motive. They claimed that he was financial, but there's no evidence to support it. So the defense is This is an insurance. This is not insurance fraud.
Yeah.
This is an insurance company doesn't want to pay.
Right.
And they're really the defendants, and we will, of course, call all the insurance people inside that worked on this claim, because and when they produced records, they redacted some of them. In other words, they blackened it out so you can't see what's in there.
Yeah.
So we know there's stuff that was going on that we're going to find out about somewhere down the road.
Mm-hmm.
So let me tell you briefly for the folks, so you know how it works procedurally. It starts out after the lawyers meet and confer. Each side participates in the picking of the jury. It's called voir dire. We've talked about how you pick juries.
Yes.
Anybody that tells you they know how to pick a jury is lying to you. It's all a big crapshoot. It's Forrest Gump. You really, you have no clue what you're going to get. I've picked some jurors and said, oh, well, I was going to run out of challenges, and they turned out to be fabulous. And I've picked some jurors that I thought were going to be great. They smiled at you all the time, and you said, oh, I love that juror, right? It wasn't Garcia, I'll tell you that. Remember the story about Garcia?
Yes.
And you guess wrong. It's nothing more than a guessing game. And you need all 12 jurors in a criminal case. Different than a civil case, you need 9
Right.
in California. So in a criminal case, it's all 12. All you want to do is get one.
One, and it's a hung jury.
One is a hung jury. Yes, indeed. If you can hang them, you can beat them. That's what we used to say. That's what we used to say. When I was on the other side, it was different.
I bet.
Oh, it's so much easier to be a DA. Oh, world of difference.
Yeah.
You got unbelievable resources.
Please, everything's on your side.
Everything.
Everything. The police,
including
the investigators.
Including the inference that the cops never lie.
Right, of course. They never lie. Sure.
Is that really true?
Come on, man. We know.
My goodness.
My dad used to say that. I shouldn't say it. Go ahead.
So after you pick the jury, or you unpick the jury, is really what you do. And you've used your challenges. You have what they call a challenge for a cause. Somebody in the jury says, I can't be fair because I hate you.
Right.
Versus peremptory challenges, which is, would like to thank and excuse juror number 6.
Because they smell.
You don't say anything. And you got to keep in mind, for young lawyers, keep your eye on what jurors are talking to each other during the breaks.
Yeah, right.
Because they develop bonds. And if you kick off juror number 5 and they were sitting with juror number 6 and having coffee every day, they're angry that you kicked off their friend.
Right.
So everything is subliminal.
It's weird.
It's not weird.
I'm just saying you
got to watch body language. You got to watch what they're saying.
Yeah.
It isn't what they say. It's the way how they say it. It's the old expression.
It's like an art.
Yeah. So now you've unpicked the jury. You've used all your challenges.
Mm-hmm.
If you run out of challenges, you got what's there, and that's always a risk. So then the next step is the prosecution makes an opening statement. The University of Chicago ran a study many years ago that said 90% of the juries decide cases on the opening statements.
Really?
Yeah. It's very important. That's why I always took a lot of time to put together an opening statement. You can't argue it. You have to say what the evidence is going to show. So every now and again you say, and the evidence will show, and then you do whatever you're going to do. And the evidence will show, and you do whatever you're going to do. So the prosecution makes the opening. Defense gets an opportunity to make an opening at that time or reserve the opening until after the prosecution is rested. I generally made the opening right then and there, right after the DA, because you don't want to leave them thinking they're going to hear one side for a long time. It's too long before they get to hear you.
Yeah.
That's a strategy call. Much of this is all about strategy. It's about psychology. It's about selling. Your lawyer's got to be a good salesperson. Very, very important. You have to know how to sell.
Yeah.
And you have to know what you're selling and to whom you're selling it.
Yeah. You got to be believable, too.
And you got to be an actor.
Yeah.
You got to smile. And it's different than a non-jury trial. When you only have a judge, you don't care so much,
Right.
But when you have a jury, you watch them from the minute they walk in to the minute they walk out.
You got to perform.
You do. It's a show. It really is a show.
I know.
You put on they put the opening argument, you put opening statement. You do the same. Then you have the body of evidence. The prosecution puts all their witnesses on. You cross-examine all those witnesses to try to impeach. It's called impeaching. You try to impeach that witness. Then you generally make a motion to dismiss, which is generally denied on the grounds that they didn't prove their case. Then you put your case on as a defense, whether you call your client or not. Judgment call.
Mm-hmm.
My preference is not to call the clients for the reasons I've mentioned
Right.
many times before. Then the jury gets what they call instructions. Instructions are given by the court either before the closing argument or afterwards, depending on what the judge's practices may be. And he or she tells the jury, this is the rule in California, this is the rule wherever state you're in. This is what has to happen if a witness was caught lying. There's a jury instruction that says a witness who was not telling the truth should be disbelieved in any other testimony except, and the judge sits there and reads it. And sometimes those instructions will take them an hour to read. And they print them up and they give them copies to the jury to take into the jury room. That's where they go. The deliberations are held in a jury room.
Did they really read the,
Sometimes. Look, I told the story many times about the jury that made a mistake.
Yeah.
They thought that they have to have all 12, didn't realize you could have a hung jury, and they voted not guilty, and the guy walked out the door.
Your guy.
My guy walked out the door with his 2 priors. And a story, I was going to say a story for you another day, but I've already told the story.
You told it.
Too many times.
Yeah. So
anyway, so the bottom line, they go in and they deliberate, and the bailiff takes charge of the jury. The judge reads the instruction and says the bailiff is going to take you, and you can't talk to anybody, and you have to talk only to yourselves and hear the rules. And they go out and they deliberate. And when they finally reach a verdict, they come in. There's a verdict form. They give it to the bailiff. The bailiff gives it to the judge. The judge looks at it, gives it to the clerk usually. The clerk reads the verdict in to the audience, to everybody.
Right.
And so you get that shot of O.J. standing there when they said not guilty.
Thank you. Thank you.
But sometimes they can't reach a decision, and the judge gives them what's called the Harris instruction, which is basically go back and try it again.
Right.
Keep on going. Keep working. It's kind of like the dynamite jury instruction to the jurors when finally they come back and they say, we can't do anything.
Yeah.
It is a hung jury. Can they retry that defendant?
Yes.
Absolutely they can. If they find the defendant not guilty, can they retry the defendant?
No.
No, they can't.
No.
And so in the case that I have just given you, the evidence offered by the prosecution is what I mentioned to you, circumstantial. And the defendant's evidence and arguments are what I basically told you. Cell phone didn't mean anything. Taxes were paid, not in a financial difficulty. Didn't know these people beforehand. Didn't know them before the water law, so how could I be conspiring with them? Those are the issues. So now we're going to leave it to the audience. This is the first time we're trying this, by the way. So if there's little flaws in the presentation, my apologies. I'll make it better the next time if you send me your comments. So vote. Send me a note. Ask Herb at AskJudgeHerb@gmail.com.
There you go, Judge.
I get flustered.
That's all right. Well, listen, I mean, if you want to give the judge a verdict.
Yeah, guilty or not guilty.
Go to his email. Send him an email. You can hit him up on Facebook, too. He's on Facebook, Judge Dodell.
We're even doing YouTubes now.
YouTube.
We're getting modern.
We're getting 21st century here, Judge. It's great. But if you want to email him and give him a vote of guilty or not guilty, ask Judge Herb @gmail.com.
And let me know if you'd let that evidence in too. With the prior acts and when did the conspiracy end. Write your comments. I'd like to know.
The shady thing was the flapper incident where the guy had I'd have to,
You got to say, if he did it before.
He did it
By the
again.
way, just one last comment. Normally, statements that are made out of court are called hearsay. They're not admissible in evidence.
Right.
But for those of you who are interested in criminal law, there's an exception to the hearsay rule. Statements of a co-conspirator during the committing of the conspiracy is an exception to the hearsay rule.
Very interesting, Judge. I like this. I like this new concept. We got to do it more often.
We're going to do it. Yeah, we are going to do it.
All right, cool. All right. Have a great week.
Well, we'll see you next week.
Okay.
KCAA Loma Linda, 1050 AM, 106.5 FM, and now 102.3 FM.
It's easier than you think. Let the pros at Cali Vegas give you a free talent evaluation. Call 949